This video is intended to provide information for parties who are seeking and who are responding to a request for a domestic violence restraining order. In these comments, when I refer to the protected person, I mean the person who is asking for the restraining order. When I refer to the restrained person, I mean the person against whom the restraining order is sought. The first thing you should know in a domestic violence restraining order, the court may make orders that limit a person's conduct in several different ways. These orders may include an order not to abuse the other party, a no contact order, and stay away orders. A restraining order may include one, two, or all three of these provisions. The first type of conduct order is an order not to abuse. This is where the court orders the restrained person not to do certain things, such as harass, attack, threaten, follow, stalk, damage or destroy the personal property, disturb the peace, keep under surveillance, annoy, block the movements, or disturb the protected person. The restrained person may not disturb the peace of the protected person or exert coercive control of the protected person. This also includes no pushing, shoving, throwing things, swearing at, or insulting the protected person. An order not to abuse allows the protected person and the restrained person to be together if that is what the protected person requests. The second type of conduct order is a no contact order. It means exactly what it says. With this kind of order, there can be no direct contact by any means, including no phone calls, no text messages, no mail or email, and no internet contact, including social media or any other electronic means. It also means there can be no indirect contact through friends or relatives or using others, including children, to send messages. The third type of conduct order is a stay-away order. With this order, the restrained person must stay a certain distance away from the protected person. The typical distance is 300 yards or the length of 3 football fields. The stay-away order can include the protected person's home, car, job, school, childcare, or other location. The court may order 1, 2, or all 3 of these types of conduct orders against the restrained person if there is enough evidence to do so. Restrictions on restrained persons. If the court has issued a temporary restraining order against you, or if a temporary or long-term order is issued against you, then the following laws apply to you. You cannot have or use any guns, firearms, or ammunition while a restraining order is in effect. It is both a state and federal crime to have any guns, firearms, or ammunition while you are subject to a restraining order. If you have not done so, you must immediately sell or surrender any guns, firearms, or ammunition to a licensed gun dealer or law enforcement. Please call ahead to law enforcement rather than walking in with firearms or ammunition. All weapons should be unloaded and transported to law enforcement in the trunk of the automobile. All restrained parties should file a Form DV-800 with the court immediately to reflect your compliance or that you do not own or have access to guns, firearms, or ammunition. This form may be obtained through the Self-Help Center at the Family Law Justice Center or the Judicial Council website, www.courts.ca.gov. If the court has information that you have guns or ammunition in your possession, then you will be required to return to court in a few days for a gun surrender hearing to show proof of surrender, sale, or storage. In the event there is a factual dispute as to whether the restrained party has guns, firearms, or ammunition, and the court makes a finding that the restrained party does have guns, firearms, or ammunition, the court will provide those findings to the district attorney as ordered by law. It is a crime to violate a restraining order even while it is in the temporary phase, and you can be arrested for violating a court order. For instance, if the order says you cannot contact the protected person, but you send them a text message, that is one crime punishable by up to 1 year in county jail and a $1,000 fine. Each contact in violation of the restraining order is a separate law violation and is punishable in the same way. Furthermore, the court may consider this at the trial on the restraining order. Also, in all of the cases where the restrained person has a child under the age of 18, the law requires that I tell you about Family Code Section 3044. This law says that if the court grants a restraining order against you, then there is a rebuttable presumption that you cannot have or share legal or physical custody of your child unless the court finds it is in your child's best interest. In most cases, you will still see your child or children, but there may be restrictions on when you see your child or how you see your child, and when your visits may have to be temporarily supervised. The visits may be professionally supervised by an agency. A list of providers who have met the state requirements are listed on the court's website. Oftentimes, the restrained party will be ordered to pay for that provider. Sometimes visitation may be non-professionally supervised. If this is something you are interested in, please ask family members or friends in advance of the hearing if they are willing to accept this responsibility. The person should be someone the other party will not object to and someone who does not have a conflict. You may overcome Family Code Section 3044 when you show the court you have completed your court-ordered domestic violence class or other classes the court orders you to complete, by not violating the restraining order, and by showing it is in your child's best interest for you to share custody. The reason Family Code Section 3044 exists is because domestic violence hurts children of all ages. Many children who are exposed to domestic violence, whether they see it or hear it or see the results, will suffer short-term and long-term emotional damage. Research reveals that even babies who are exposed to domestic violence can be harmed. All children may be impacted developmentally by exposure to domestic violence. In the event that the restrained party has a child in a different relationship, Family Code Section 3044 may apply to custody and visitation orders in that case. The court process. There are 3 important things that you should know in advance of the initial hearing. Those are proofs of service, continuances, and what will happen in the courtroom. Proof of service. In most cases, the law requires that before the restraining order hearing may occur, the restrained person has to be told about the hearing through something called personal service. This means that somebody other than the protected person who is over the age of 18 has to hand deliver the request for a restraining order to the restrained party. Then the person who delivered the papers needs to complete a proof of service form. The proof of service should be filed with the court in advance of the hearing. The protected person should also bring a copy of your proof of service to court with you. Page 2 of the request for a domestic violence restraining order sets forth the number of days in advance of the hearing that service must occur. If the restrained person has not been personally served, the court may continue the case to give the protected person another opportunity to have the court papers served. The temporary orders will remain in effect until the next court date. Continuances. Sometimes a case must be scheduled to be heard on a different day. This is called a continuance. At the first hearing, the restrained person has the automatic right to one continuance to file a response or seek the advice of an attorney. In addition, either party may ask for a continuance to a different day, which the court may grant if it finds there is good reason to do so. If either party has a criminal case pending, parties may not want to have a hearing at the first appearance because anything said in family court may be used against you in your criminal case. In your criminal case, you have a Fifth Amendment right against self-incrimination, which means you have the right not to say anything that can be used against you in your criminal case. If you want to assert your right not to say anything in your family court case that could be used in your criminal case, then you should request a continuance to give you time to finish your criminal case. That does not mean you can delay your family court hearing indefinitely, but it means the judicial officer may give you a reasonable time to finish your criminal case. Usually, restraining orders are set on the court's law in motion calendar, along with several other cases. If you believe your matter requires more than 20 minutes in total, it is important to tell that to the judicial officer and explain why. For example, will witnesses to the domestic violence testify? Are there documents or videos for the court to review? Please consider these factors and any others in letting the court know how much time you will need to present your case so the judicial officer can schedule the matter to a different date to give you sufficient time. If the case is continued to a different day, any temporary order may be extended, and they can also be changed if there is a reason to make changes. If you would like to continue the hearing on the restraining order to a different day, but would like to ask for orders to see your child or children, the court may grant the opportunity to have a short hearing on just that issue. At the time of your hearing or trial, the protected party presents their case first. This may include testimony by witnesses who have seen or heard relevant events, photographs, messages between the parties. The restrained party will then have the opportunity to respond to and present their own evidence. Any exhibits for the court shall be in hard copy form with at least one additional copy for the other party. Any audio or video records must be on a USB, and the California Rules of Court require a transcript of the recording. If a restraining order is granted, your immigration status may be impacted. Neither party should mention the other party's immigration status. As a reminder, if the court has already issued temporary restraining orders against you, the order remains in effect while you are in the courthouse. The court recognizes you cannot be 300 yards away from the protected person in the courtroom, but please understand if you walk over to the protected person or speak to them or mouth words to them or make faces or gestures to them, then you may be in violation of the temporary restraining order and a deputy can arrest you and you can be taken to jail. Also, please do not send friends or family members over to talk to the protected person, as that may also be a violation of the order. This means you cannot wait until after the hearing and communicate with the protected person in the lobby outside the courtroom or in a nearby parking lot. Again, that could be a violation of the order and you can be arrested. Support services. There are services in Santa Clara County to help all of you. The Domestic Violence Intervention Collaborative are available for people appearing in court. They can help both protected persons and restrained persons. In addition, the Restraining Order Help Center at court can assist both parties with filling out the correct paperwork. Also, if you have a child living with either parent under the age of 6, there is an organization called First 5 that may be of assistance to you. First 5 is an organization that can help connect your family to free services to help improve your child's health and behavior. If you want to be contacted by First 5, there are postcards and a white box near the door in the courtroom. Just complete the postcard and someone will contact you to see how they can help. If you are appearing remotely for your hearing or wish to contact First Five in advance of your hearing, you may contact them at 408-534-5675 or at www.first5kids.org.